This is Barry Zalma on insurance. I'm an attorney who is retired from the practice of law and now spend my time as an insurance claims consultant, expert witness, author, and producer of these videos. Today I'd like to talk about the relationship between an insurer and its defense counsel. Whenever an insured is sued and requires a defense, or the insurer is sued, the insurance adjuster and the defense attorney must understand their respective roles in preparing the case for trial. They must develop a rapport with each other and with the insured person or entity that is being defended to make communication easier to maintain. Bad faith lawsuits and poorly tried bodily injury cases seem to arise when the adjuster and the defense attorney fail to communicate regularly with each other and the policyholder. At the first meeting, the attorney and the adjuster should agree on the division of labor with regard to the preparation of the case according to their respective training and experience. Counsel and the claims person should reach an agreement regarding the handling of the case. Claims adjusters often mistakenly leave all investigation tasks to the attorney. Most adjusters are also investigators and are trained to fulfill the duties of an investigator within their narrow field of expertise. Therefore, the adjuster should do as many informal interviews of witnesses and parties as possible and provide the results to the attorney. The attorney should limit his or her investigation work to the preparation of witnesses before trial or deposition. Work that is usually done by the attorney or by a legal assistant include 1. Meeting with the insured to obtain facts for answering interrogatories. 2. Interviewing the insured and key witnesses, including getting recorded statements from each. 3. Collecting and preparing documentary evidence such as medical records, police reports, and employment records. 4. Preparing responsive pleadings to lawsuits. 5. Preparing for and taking depositions of parties, including the plaintiff or the defendant or an independent witness. 6. Preparing written discovery such as interrogatories, requests for admission, and requests for production of documents. 7. Preparing, filing, and arguing motions with the court. 8. Preparing mediation briefs. 9. Attending and negotiating potential settlement at mediation or court-ordered settlement conferences. 10. Preparing motions in limine before trial to prevent the presentation of difficult or unethical type evidence. Preparing trial briefs for presentation of the court before trial begins. Preparing evidence and witnesses for trial, and finally preparing evidence and arguing legal issues at trial. Insurers and their adjusters need to understand that there are challenges to the use of in-house counsel. Defense counsel are sometimes employees of an insurance company. Some attorneys have challenged the use of in-house counsel on the ground that the insurer, as an employer of attorneys, is not licensed to practice the law. They claim that the insurer was engaged in the unauthorized practice of law, which in many states is a crime, if not all states. Attorneys have also raised challenges against House Counsel because the employee attorney is alleged to be serving two different masters. As an employee of the insurer, it is alleged, the attorney cannot do justice to both his client, the insured, and his employer, the insurer. A Texas Court of Appeal refused to limit the right of insurers to hire staff counsel. In American Home Assurance Company versus Unauthorized Practice of Law Committee, the court stated, quote, American Home and travelers may use staff attorneys to defend claims against insureds, provided that the insurer's and insured's interest in the situation are congruent, as described in this opinion, but staff attorneys must disclose their affiliation to their clients. Another Texas court concurred and stated, quote, use of staff attorneys to represent insureds is not the unauthorized practice of law. As Utilities Insurance Company versus Montgomery, a Texas Supreme Court decision in 1940 pointed out, the insurance company, in providing an attorney to the insured, is seeking to protect its own interests, even though the attorney does represent the insured. The insurance company is not practicing law because of the company's direct financial interest in the litigation against the insured. There is no violation of Texas Business Corp Act annotated Article 2.01b, paren 2, close paren, because the purpose of an insurance company is to indemnify its insureds. The agreement to defend and pay attorney's fees is collateral to that purpose. Consider Unauthorized Practice of Law Committee versus Nationwide Mutual, a 2004 decision of the Texas courts. 6 of the state court decisions have cited Utilities Company versus Montgomery as supporting the majority rule. Even though Montgomery involved the use of outside counsel, even in Gardner versus North Carolina State Bar, which held the use of staff attorneys constitutes the unauthorized practice of law, pointed out that Texas has a special rule for companies and cited Montgomery. In Cincinnati Insurance versus Wills, a 1999 decision, the precise question was whether an insurance company engaged in the unauthorized practice of law when it employed house counsel to represent insureds. Specifically, the plaintiffs in Wills sought to disqualify the defendant's insurer from using house counsel, arguing that it amounted to the unauthorized practice of law. The court held first that the use of house counsel to represent insureds did not necessarily amount to the unauthorized practice of law, and second, that in-house attorneys appearing as counsel to defend claims against an insured did not necessarily trigger an impermissible conflict in violation of the rules of professional conduct. In reaching this holding, the court made several observations about the notice required to a policyholder regarding the possibility that house counsel may be used for claims defense. Evidence presented to the court that contended that State Farm either one, delivered a product different than the promised in the policy, which stated clearly that it would provide counsel of its choice in the event of a lawsuit, or two, was unjustly enriched by its house counsel arrangement. As the Indiana Supreme Court noted in Wills, that stated that, quote, in the realm of insurance defense, the public may ultimately reap the benefits of better service at lower cost through the use of house counsel. This hardly sounds like the makings of a claim of unjust enrichment. The reasonable market value of the attorney's services is the measure of a reasonable hourly rate. This standard applies regardless of whether the attorneys claiming fees charge nothing for their services, charge it below market or discounted rates, represent the client on a straight contingency fee basis, or are in-house counsel. For example, in PLCM Group versus Drexler, the California Supreme Court in the year 2000 affirmed the trial court's award of prevailing market rates to a corporation represented by salaried in-house counsel. The court explained that the fee-setting inquiry in California ordinarily begins with the lodestar, that is, the number of hours reasonably expended multiplied by a reasonable hourly rate. California courts have consistently held that a computation of time spent on a case and the reasonable value of that time is fundamental to a determination of appropriate attorney's fees awards. The reasonable hourly rate is that prevailing in the community for similar work. Of course, the defense attorney, whether a house counsel or an independent lawyer, should be required to report to the claims person and the insured defendant on a regular basis, and the adjuster should establish reporting requirements clearly with the attorney. Reporting requirements, therefore, should include, at a minimum, 1. That the attorney report the progress of the case no less than every 60 days to the claims person and to the insured, even if the report states nothing new has occurred. 2. That copies of all pleadings filed by both the attorney and his or her opponent be delivered to the adjuster and the insured. 3. That the attorney need send only one copy of each pleading to the adjuster and the insured, regardless of the number he or she may receive. And 4. That with regard to answers to form or pattern interrogatories, requests for admission, requests for production of document or other written discovery, and minor pleadings such as demands for jury trial or notices of continuance, the attorney should use his or her discretion as to whether to advise of the existence or just summarize or to send copies to the adjuster and the insured. If the case is complicated or has multiple parties, the adjuster may wish to keep only a skeleton file of pleadings and discovery, or a digital one, and obtain summaries of relevant pleadings and discovery from the attorney. Now that technology permits it, the attorney should be asked to avoid excessive use of paper documents and instead send copies of the documents, pleadings, discovery, and correspondence in electronic form. This video was adapted from my book, Zalma on Insurance Claims, Part 108, Second Edition, which is available as both a Kindle book and a paperback from Amazon.com. If you found this video to be of interest or to use to you, please convey it or forward it to your colleagues. It's free. And please also subscribe to my YouTube channel, my Rumble channel, and my blog so that you can be advised of future videos. All 10 volumes of Zalma on Insurance Claim are available from Amazon.com. Thank you for your attention.